Good morning, everyone. My name is Xochitl Leon, and I'm the chair of the Enforcement Program Oversight Committee. I want to start by apologizing for being a little late and shifting the team schedule. So I'm happy to be here, and I did learn that there are several campuses. First is Fullerton, and the Irvine is much smaller and less crowded. Before we start taking roll, I want to make sure to remind the team that we will be having a mandatory fire drill and evacuation in 10 minutes. So for those of you who are watching the webcast, we want to let you know that we will be evacuating at 10:10. We will be exiting the library using the east doors and proceed north to the engineering and computer science. So back here? Yep. Okay, in the back of the room. We will be proceeding north to the engineering and computer science lawn, and we will gather near the fallen statue of David. The library evacuation map has been provided to all the members and can be found on the back of the table. Once the drill is completed, we will reconvene and continue from where we left off. At this point, I would like to take a roll call. Can we start on this side of the table, please?
Dan Jacobson.
Alicia Burhow.
Kathleen Wright.
Excellent. Thank you. So we're going to try to move fast this morning and see how much we can get in 10 minutes. But starting with agenda item number 1, which is the approval of the minutes for the month of May 18th. Are there any comments in regards to the meeting minutes?
I think we just need a motion, right?
Yeah. So do I have a motion to approve the minutes?
I'll move to accept the minutes.
Any comments?
Need a second.
Do we have a second?
A second, sure.
Thank you. Awesome. All right, can we call for a roll?
Xochitl Leon.
Okay, sorry, I'm skipping ahead here. Are there any public comments?
Sorry.
All right, we can do the roll call now. Thank you, Nishi. Thank you.
Xochitl Leon,
Yes.
Kathleen Wright,
Yes.
Dan Jacobson,
Abstain because I wasn't here.
and Alicia Burhow.
Yes.
All right, motion approved. Let's move on to the second agenda item, where we're going to discuss the cost recovery of investigation and prosecutions for the CBA. I believe this is a follow-up from a recent meeting. If I can have Mr. Francello please provide us an overview on the great paper he put together.
Thank you. I appreciate that. This agenda item is basically informational in nature regarding cost recovery and how it is used in the disciplinary process and is being brought before the CBA at a member's request. So there is no specific action required on this item. But in attachment 1, I've provided Business and Professions Code 5107, which authorizes the CBA to recover investigation and prosecution costs. It is important to note that the CBA is a licensing fee generated agency and does not draw any monies from the state's general fund or related tax dollars. The licensing fees are the sole monies used to support the regulatory functions of the CBA. The CBA maintains 18 staff members primarily charged with performing its investigations. These are permanent members of the CBA, and their salaries are accounted for in the annual budget associated with personnel costs. The CBA's budget is drafted without consideration to enforcement-related income. The CBA kind of orders costs in 2 ways, either as part of a proposed decision or as part of their stipulated settlements. In attachment 2, I've provided a case that was decided by the California Supreme Court referred to as Zuckerman, which set forth the standards by which licensing boards must exercise its discretion to reduce or eliminate awards to ensure the board does not deter licensees with potentially meritorious claims from exercising their administrative hearing rights. In a recent matter decided and ordered by the CBA, an administrative law judge proposed a reduction in the cost and included a citation to the Zuckerman decision. The CBA adopted the corrected proposed decision, which reduced total cost. As for stipulated settlements, which are the bulk of the disciplinary matters brought before the CBA, cost recovery is a standard term and condition, except in those matters related to applicants, but for petitions to revoke probation. But for the majority of the accusations you see, it is a standard term and condition. When evaluating cost, I do not and should not consider it to be a penalty, and I maintain an awareness along with the Deputy Attorney General working the matter of the Zuckerman case. Cost recovery is often a primary concern or a sticking point during the settlement discussions, and this is often the one term that can cause significant delays in resolving a matter. As consumer protection is the CBA's ultimate goal, and resolving a matter quickly as possible and practicable furthers that goal, by negotiating a reduction in cost, cases oftentimes resolve quicker. This allows AG's office and staff to focus and work other cases, and at this time, as there's no action before the board, staff have no recommendation, although I do appreciate the opportunity to maintain the ability to reduce costs as part of the settlement discussions. At this point, I'd like to turn discussion back over to the chair, and I'm happy to answer any questions members may have.
Yes, Ms. Wright.
What time are we break? Is it 10 o'clock?
10:10, we have 5 minutes.
10,
Five
okay.
minutes, yeah.
All right, I'll be brief. One, thank you, Dominic, for the material and the information that you've provided. I have a couple of detailed comments, but one overall comment, which was the essence of my request to begin with, and that is that when the board considers a scenario for a stipulated settlement or any other matter, and the regulation that you do cite on disciplinary proceedings does require that if reasonable cost awarded shall be reduced or eliminated upon a finding that respondent has demonstrated that he or she cannot pay all or a portion of the cost. My concern is that I have yet to see any demonstration in any of the stipulated settlements regarding why it is that we are agreeing to reduce the costs. My parallel or basis of experience in this area is with offers in compromise in the tax arena, where if you are going to propose an offer that is less than what the agency has said you owe, then, and I have the forms and package and information that you have to give the agency in order to support your claim for financial hardship. We don't even get to see a balance sheet or any indication that the individual is insolvent, and that would be the basis then for being unable to pay. That being the case, my request was that either yourself as staff and or including the information in the pink sheets, that you simply tell us why it is that financial hardship is warranted in a particular case. That's the big point. The detail, Zuckerman actually reversed the Court of Appeals, the California Supreme Court reverses the Court of Appeals with respect to allowing cost recovery in the case of that chiropractor. And it made it clear, that ought to be a textbook administrative law case, because it made it clear that the requirement to meet the threshold of due process is minimal. And it says so right in the decision. In the second case that you gave us, the reason that the judge in the first amended accusation against Jerome Kaiser did not allow full cost recovery was because you didn't give him a breakdown of the costs. He asked for a breakdown of the costs and you didn't provide it, so he said, that being the case, I'm not going to allow cost recovery. And it's right here, I have the page number.
So if I can speak to the first part of your comment, the section that you're referencing in 5107E is specific only to administrative law judges in relation to...
All right, I think we're going to have to...
2 minutes early.
Yes, we're going to adjourn for the meeting, for the fire drill, and we'll reconvene in a few minutes. Thank you. This is the Enforcement Program Oversight Committee for the California Board of Accountancy, and we're rejoining the room after a fire drill here at Cal State Fullerton. So we're going to pick up on agenda item number 2, and I'm going to cede the floor back to Mr. Dominic Manzella to continue the discussion.
Thank you. So, Ms. Wright, in response to the first part of your question related to 5107 and specifically subsection E, that specific subsection is related only to administrative law judges, not to staff. So the ALJ is required to follow that particular subsection in reasonable cost awards and reducing or elimination of the costs. As for the Kaiser matter, in which the judge, ALJ, proposed a reduction in cost, we did provide a certified statement of cost, which we do in every case, and he chose not to, he didn't believe it met the standards required in the, I believe it's the APA, and disallowed the cost, but he did also reduce the cost that the AG's office had presented and didn't find them unreasonable. He reduced them related to, in light of the circumstances for the respondent in that particular matter. So as for stipulated settlements, financial hardship is just one of many things I will consider as part of a cost reduction. Financial hardship is not the sole means or sole reason by which I would consider reducing the cost. I could, as I mentioned in the paper, I would consider reducing the cost in the expedition of getting the matter resolved in the interest of consumer protection. I'd rather not continue to battle back and forth with respondent and counsel for potentially a couple extra months in the interest of a few $1,000s that I can get the matter resolved, bring it to the board for its consideration in the interest of consumer protection.
Okay. I'll be brief then in my response.
And I have a question as well, too, Ms.
Sure,
Wright.
go right ahead.
Well, my question is, real quick, is when we are working with folks like Mr. Kaiser or other potential CPAs that we're working to close their cases, as long as our cost recovery in terms of, as long as we meet the minimum, I mean, isn't that kind of the goal? I would rather see cases cleaned up and cleared and having people move on their way, as long as we have our, the absolute funding necessary moving forward. Does that make
So
sense?
again, there's no costs, enforcement-related costs are negligible in the board's budget. So any cost recovery is really not budgeted for at all.
Okay.
I've even presented this board total elimination of costs as part of a matter. So there's not a threshold for some amount of money that needs to be collected as part of cost recovery. The only requirement is I don't go over the amount. And in your materials, you get an approximate cost, and it doesn't exceed the cost being recovered. So again, as I mentioned, I pay attention to the Zuckerman matter. I pay attention to the financial hardship. There are instances where I'll reduce it without even financial hardship. I just do it in the interest of getting the matter resolved if it ends up being the sticking point in the resolution. Because again, consumer protection is the goal, not necessarily recovering revenue that's not budgeted for.
Okay, thank you.
Yes, Ms. Wright.
Two comments. One with respect to the amount of money and where it's coming from. Generally speaking, when you are tracing funds, the theoretical discipline or framework that you follow is something called the avoided cost method. And the avoided cost method basically says that if you didn't use the money for this purpose, i.e. to cover investigation costs, then that money would have been freed up and you would have required less money from the state with respect to the overall budget request that you submit to Sacramento, to the governor. You do get money from the state, and under an avoided cost method analysis, indirectly, the monies that we forgive here are going to have to be, other expenses of your agency are going to have to be funded from somewhere and would come from state sources. That would be my analysis. That's frequently an argument used by the tax regulators. Secondly, with respect to my own analysis of these pink sheets that we get and settlements and cost recovery, I do have difficulty with meeting a clear and convincing evidence standard without having some evidence of why it is that we are reducing the cost. All I'm asking for is the reasons. If it's financial hardship, what did you look at, and did it support financial hardship? If it's some other basis, that's, I presume, okay. I'm not sure about that. But if it is okay, then what was that other basis that resulted in yourself feeling justified in using that basis for reducing costs? What I don't think I can continue to support and vote for is a settlement where costs are reduced, and I don't have any support or any documentation or analysis regarding why that took place.
So in response to your first question, again, there's no monies coming from the state. All the money's generated from the licensing agency itself. There's no general fund money, no tax dollars, there's no loss of funds to the state. So I don't entirely understand the tracing of the funds methods, but it doesn't appear applicable here. The board's personnel costs are primarily what is one of the driving forces in our investigative costs. Those are budgeted for as part of our personnel costs. The AG's cost is a line item in our budget. We monitor that. As long as we don't exceed our budgetary authority, we don't have any issues. The loss of money, and again, one of the things I'm preparing to do in an upcoming year is to show the board how much money we spent on certain investigations that were brought before the board, and then what was ordered and what we've recovered. But there's not a loss of, and that'll be general to the entire, to all the orders, not one specifically, but there is no lost monies.
Okay, you and I don't agree on that, but that's fine. But on the second point of the clear and convincing evidence standard that we're supposed to use in addressing these matters, can you provide us with, you said you could provide us with a little bit, not a lot, of detail of the breakdown of the costs, and then secondly, the portion of those costs that you do recover.
Yeah.
And then just a sentence regarding the reason why you chose to forgive whatever.
So the cost recovery is not held to any clear and convincing standard. That's just whether or not the board believes the terms and conditions outlined in the order are reasonable. The clear and convincing evidence really is only a standard if I go to hearing, and when I filed the accusation that I believe there was clear and convincing evidence to that matter. So the standard terms and conditions and probation are simply those, as well as the order itself, are those that the board deems reasonable in the resolution of the matter. So there's not a clear and convincing standard there. As for what I provide you in the pink sheets for the cost, I believe that is the extent of what I can provide. I'm happy to provide some information during closed session, but why I reduced the cost, or why I considered reducing the cost of negotiation, is a negotiation issue, and the other party is not here to speak to their side of that particular matter, and why that is a reasonable assessment in reducing the cost. So there is some limitations. So the only thing I believe that I can present is what I present now, which is I'm not exceeding the costs associated with the investigation and prosecution of the matter.
Okay, and thank you, and I appreciate your opinion in that. That does leave me with an uncomfortable feeling, which going forward would mean that I will vote against any instance when full costs are not recovered and no explanation is provided.
Yeah, I think this is interesting because I think when we're assessing the issues, we're going back to our mission, right? Mm-hmm. What is our mission? And I'm not here in the practice of assessing and evaluating cost recovery. I really look forward to our experts, our staff, who are making decisions that they leverage for negotiation purposes. And they might not be rational on paper, but I think they're critical negotiation tactics to move forward in close cases so that we can continue to protect the consumers of California. So unless there's any discussion.
Well, and I would agree with you on that. I've been on this board now for 6 or 7 years, and when I first came on the board, we only had a few cases every time. And I felt like we didn't get to everyone. We didn't get to everybody. There was a backlog of a lot of things, and I want to be able to get that cost recovery, get what is needed, get these cases closed, and then let our CPAs, if they're deemed worthy to serve the public, back in and earning a living. So I'm with you. I'd rather. And we can discuss this more with staff, at a further time, but I would rather see cases closed and have people get back into the practice of accounting if that's a possibility.
Any other comments? Comments from the public? Okay. So moving on to our last agenda item, we want to see if there are any future topics that we would like to discuss in this committee. Yes.
Okay. I don't know if these two topics belong here or belong elsewhere on the agenda, so please let me know because I didn't know where to put them. We had an FTB advisory board meeting in the last, I don't know, 7, 8 days or so, and they have initiated a practitioner compliance project at the FTB, and I got names and so forth, which I sent to CBA regarding this project and the fact that it might be something that CBA would be interested in and interacting with the Franchise Tax Board. They would be very receptive to having CBA work with them on this project, focusing on practitioner compliance. So that's one thing that I wanted to mention at some point over the course of the agenda.
So let's take that. Is that in scope for the goals of this committee, or should we take that offline for a separate committee or open agenda item?
Or it could be something for a future agenda item at the full board
At
meeting.
the full board
The
meeting?
full board?
That's
Okay.
what I'm thinking. Because I don't know if this is something that would relate to EPOC.
Enforcement, yeah.
Right.
Enforce,
So why don't we
your
take-
guidance, whatever,
yeah, no,
what do you, just tell me what you want me to do.
My recommend, oh, I'm
Go
sorry.
ahead. We'll definitely take that as an agenda topic for a future meeting for the broad
For the full
CBA
board.
Yes.
full
Okay.
board, not for this committee.
Okay, very good. The second item does relate to cost recovery, and in light of the fact that they are the experts, and they also had a big project on offers and compromise and so forth, which we talked about at length in that advisory board, but they too said that they would be more than willing to work with any state agency with respect to cost recovery and lend their expertise with respect to how they go about it, the procedures they use, the documentation that they require, and so forth.
Okay, I think that's duly noted. Let's bring that up in a future agenda item. Let's
For
bring
the entire
everyone
board?
for the entire
Okay.
board, and then determine what the next steps are.
Okay.
Any other future agenda items from the public? If not, we're adjourned. Thank you.